We are delighted to welcome Shira Perlmutter as our keynote speaker. She is the Registrar of Copyrights and Director of the U.S. Copyright Office. Prior to her appointment in October 2020, the Registrar served as Chief Policy Officer and Director for International Affairs at the United States Patent and Trademark Office. And joining Registrar Perlmutter today during the question and answer portion of her keynote address are her USCO colleagues, Kevin Amer, who is Acting General Counsel and Associate Registrar of Copyrights, and Robert Kasnick, Associate Registrar of Copyrights and Director of Registration Policy and Practice. Welcome and thank you for being here. We're so delighted to have you. And with that, I will turn it over to Registrar Perlmutter.
Well, thank you very much, and good morning and good afternoon to everyone, depending where you may be. I'm really delighted to be with all of you today virtually. Now, I am relatively new at the Copyright Office. I rejoined the office where I worked many years ago, 9 months ago as Registrar, and I found I'd come to an extremely busy and active organization. I was very lucky to come back to a really superlative team at a very exciting time for copyright. We are involved in a number of absolutely transformative projects, both for the office and for the copyright system as a whole. And it's also, we just completed our 150th year, so there was a lot to celebrate. And of course, all of this is happening at an extremely challenging time with the pandemic continuing to affect us. So I think not everyone is necessarily aware of all the things that the office does. So many of you may interact primarily with the office through our services to the public, like registration and recordation. You probably also know that we're a regulatory agency, and that facet of our work has only increased over the last few years. And we also give policy advice both on copyright litigation and on legislation to the judiciary and to Congress. We issue various studies of topics related to copyright. We do legislative drafting, and we do a lot of international work, and that includes interacting with our counterpart copyright offices in other countries, and also working through the interagency process in the US government, especially on issues involving trade and intellectual property. So we're quite busy on a lot of different fronts. And I, of course, will not try to cover everything in the short period of time we have together today, but what I'm going to do is give you a bit of an overview and highlights of current and planned activities. So what I'll do is to start with a snapshot of where the office is today and how we've weathered the pandemic, then talk about my main strategic goals for the office going forward, and then I'll end with a summary of our current major initiatives. And hopefully there will be enough time for questions and answers at the end. So first of all, what's been going on during this difficult period of time with the pandemic raging? The Copyright Office, I'm very happy to report, has maintained its ability to provide services with only very minor disruptions. And we've even made substantial progress and been quite productive during this time. So unlike the PTO, we did not have most of our staff teleworking, but we were able to move fully 98% of our staff to telework almost overnight after we had to exit our building in March 2020. And we've taken a number of steps to make sure that the public can access our services despite the disruptions of the pandemic. So Congress passed the CARES Act last year, and that gave us greater flexibility to respond to national emergencies like this one. And drawing on that flexibility, we adapted the ways that we receive and process certain electronic submissions and applications. And we also adjusted timing provisions for situations where people couldn't comply with legal requirements due to the pandemic. We've extended those flexibilities a number of times, and we continue to review the situation. We've extended them, we've altered them a little bit, we've put some new ones into place, so stay tuned for that. Meanwhile, our legal and policy work and our efforts on modernization haven't missed a beat. And this past year has been extremely productive, as you'll hear. So first of all, we have achieved a number of significant milestones in our modernization initiative, and that involves recordation, the copyright public record system, and registration, and more on this to come. We also continue to present informative educational programs for the public, all online during the pandemic. We refreshed our website, and if you look at it now, it looks quite different from how it looked a few months ago. We've marked our 150th anniversary in various ways. We published an updated version of the Compendium of Copyright Office Practices. We opened a new state-of-the-art warehouse. And we also just updated our publication of the Copyright Act to include all the recent amendments since the last version. Now, of course, I can't tell you there was no impact on the office from the pandemic. There was. We were primarily affected with respect to those services that involve physical materials. So that includes recordation, notices of termination, registrations with deposit tickets, and mandatory deposit for the library. So because the office was physically closed for 14 weeks, and we've had a limited return to on-site operations because of social distancing, that means that handling these materials resulted in some increased processing times. So what we've been doing is to offer overtime to staff and work very hard to address the backlogs. And the good news is, this is just a temporary situation. And as on-site operations continue to ramp up, we expect to get that under control. So let's go to the next slide. On a high note, we've opened a new exhibit in the 4th floor lobby just outside my office in the Madison building. And this replaces the exhibit that some of you may remember, which was taken down about 15 years ago and never replaced until now. This new exhibit is called Find Yourself in Copyright. And I have to say, not having had a hand in putting it together myself, it is a terrific exhibit. And once you're able to come back into the office, I think you will enjoy it. So the exhibit really is intended to connect visitors with the evolution of copyright law and the office's part in that evolution, looking at the very varied nature of original works. So we hope that by building connections between the individual and the cultural legacy of the United States, we are showing how copyright serves the public by incentivizing creation and enriching our lives. So I do recommend it. Let's go to the next slide. We've been gradually opening the office, and the library has been gradually opening the building in a phased approach, responding to changes in our understanding of the pandemic and the prevention of illness. So just some pictures of employees working with masks. We had 5% of our staff return to the building in June of 2020, and just over a quarter last August, so about a year ago. And I'm pleased to announce that as of July 8th, we've been able to bring more staff on site and therefore be able to reopen the Public Information Office and the Records, Research, and Certification Service Desk. So if you need those services, they're available using an appointment system. Next slide, please. So this is just a look at our activity by the numbers to give you a sense of the scope of our work. It's interesting that during 2020, we received the normal flow of registration applications despite the pandemic. So I think that was a different experience than that of the Patent and Trademark Office, which had more of an effect. We registered almost 444,000 claims, which was about an 87% registration rate. And notable, not reflected on this slide, is that we made significant strides in improving our processing times overall. So the average processing time for applications for registration is down from 4 months in the second half of fiscal 2019 before the pandemic to 2.6 months in the second half of fiscal 2020. So that's very impressive progress. We also received and resolved 637 requests for reconsideration, which means we cleared as many requests as came in, quite impressive too. And we received also 64 second requests for reconsideration and issued 42 decisions. And then last but not least, our Public Information and Education Office was very busy answering questions and providing educational programs and materials. We fielded more than 170,000 inquiries on a wide range of topics. We produced 28 public events, and we reached millions of users through our webpage and social media. So it was a busy, interactive year, despite the virtual nature of most of these programs. And if you're interested in more numbers and more details, our annual report is posted on our website for fiscal 2020. So let's talk about plans going forward. I spent my first few months in the office on a virtual listening tour, listening to stakeholders of all varieties and to our staff about their priorities and their concerns. And based on all of that input and what the office had already been doing, I've identified 4 overarching strategic goals for our work going forward. And you can see this list: continuous modernization, copyright for all, providing legal and policy expertise, and enhanced economic analysis. So to take those one at a time, continuous modernization. So as you will hear more in a few minutes, we're deeply invested in modernizing our systems as a top priority for the office. And we have a plan in place, which we're in the middle of, essentially a 5-year modernization program. But I think what's very important is that we take forward that project and go beyond the current initiative. So once we finish the work that's currently envisioned, we can't just say now we're done and wait until our IT systems are outdated to begin again. We want to ensure a process of continuous improvement, drawing on public input throughout. We're also going to look at a variety of new projects that draw on cutting edge technologies. So once our trove of valuable data is all digitized and searchable, we want to take steps to maximize its usefulness to the public. So just to give some examples, we can connect our data sets to other reliable data sets with relevant information. And we also want to look at expanded functionalities, such as the enhanced use of APIs and of mobile apps. I know that, for example, the Singapore IP office has a system that allows people to apply to register trademarks on their mobile phones, and we'd like to think about those options as well. My second strategic goal is what we're calling copyright for all. So the idea here is to open up the copyright system and involve more participants. We want to make both the copyright law and our services as easy to understand and as accessible as possible for individuals, as well as for businesses of all sizes and levels of sophistication. So that will include not just continuing, but broadening our outreach and education efforts and focusing on identifying and reaching underserved communities. Some of the work we're already doing, setting up the Copyright Small Claims Forum, will be a very important tool in this effort. So we need to make sure that we help people understand how they can assert rights and file claims. And we've begun participating in the National Council on Expanding American Innovation, which the PTO set up last year. So we're expanding what that organization, what that group is looking at beyond just scientific innovation and looking at creativity as well. And we believe and hope that the result of all these efforts will be a more diverse pool of creativity in the long run for the public to draw on, enriching all of our culture. So the third of the goals is continuing to provide impartial copyright expertise to Congress and the courts and the executive branch. So if we can go to the next slide. We have a tremendous amount of activity going on in this area. And if you look at slide 7, this is a list of all of our open rulemakings, and you can see there are 1, 2, 3, 4, 5, 6, 7, 8, 9 of them. That's a lot. among them, one that probably people are quite aware of, which has to do with the 8th iteration of the Section 1201 anti-circumvention rulemaking, where we recommend to the Librarian of Congress exemptions to the prohibition on circumventing technologies protecting copyrighted works, where the technology is preventing people from obtaining the benefit of exceptions, of copyright exceptions. So that work continues, and our 8th rulemaking will be issued in October. If we can go to the next slide, we're also examining various policy issues and advising Congress on a number of things that are the subject of debate these days. And those topics include a couple of hot areas such as the role and responsibility of online intermediaries in dealing with online infringement, and such as the copyright issues involved in artificial intelligence, all topics that there have been innumerable conferences and hearings on. In addition, if you look at this list, you can see we've issued 2 studies in June and are about to issue a 3rd, which is on the issue of state sovereign immunity. Congress asked us to examine the extent to which there's evidence that states are engaging in a pattern of copyright infringement without there being adequate remedies under state law as a result of the Supreme Court striking down the Copyright Remedy Clarification Act in Allen v. Cooper. And the Patent and Trademark Office is doing a parallel study on state sovereign immunity against patent and trademark claims. So that will be coming out very shortly at the end of August. And then we have a whole list of requests that have come to us from the Senate Judiciary Committee to study or issue reports or do work on a number of issues. That includes, you can see the list here, ancillary copyright, which is looking at press publishers and the use of excerpts from newspapers by online services. I think this was very much motivated by the steps in Europe that passed a new law as part of their digital single market directive. We're looking at digital deposits of works and best edition requirements for the library and the relationship between what's needed for registration and for deposit. We'll be looking at deferred examination of registration claims, which some right holders have asked for. We're looking at the meaning of publication in the online environment. We're looking at what we've already started looking at. We had a series of roundtables last September at the role of standard technical measures as referred to in Section 512 of the DMCA, which says that online service providers, as a condition for safe harbors, are supposed to not interfere with standard technical measures that are used by copyright owners. The question is, what are such standard technical measures and can they be developed, since they have not yet? So stay tuned, because you'll be hearing more from our office on that. And then last but not least, there's been some recent state legislation requiring publishers to license ebooks to public libraries. And Congress has asked us to look at the extent to which those laws may be preempted by the Federal Copyright Act. So all of that work continues. Now, these are important matters. I could spend the rest of my time talking about these issues, but let me move on. And then, of course, happy to take any questions at the end. So what I want, before we get to the current initiatives, sorry, if you can just go back, the 4th of the policy goals, of the strategic goals, is to enhance economic analysis at the office. So I want to enhance our development and use of data by adding in-house economic expertise. And that will involve hiring a chief economist for the office to assist in producing and analyzing the factual evidence on which we will base decisions about both policy matters and financial matters. And in my experience working at the USPTO, I saw the tremendous value that the Office of the Chief Economist contributed to the agency's initiatives. We'll be posting that position in the coming months. And meanwhile, I'm pleased to report that we've brought in Joel Waldfogel as the 4th Abraham Kamenstein Scholar. Professor Waldfogel holds the Frederick Capel Chair at the University of Minnesota Carlson School of Management. And he is a very well-known scholar who's done extensive work on the economics of copyright markets and industries. So he's going to be working with us to develop an economic research program for the office. In fact, he is already working with us. All right, so let's now turn to the 3 major initiatives that I inherited when I came on board. And each of these is really transformative in its own right in its particular area. And that is the Copyright Small Claims Forum, or the Copyright Claims Board, CCB, the Music Modernization Act, or MMA, and Modernization of Copyright Act Services. So as to small claims, we don't have a separate slide on this, but we've been extremely busy since Congress passed the CASE Act in December, requiring us to set up a small claims forum within the Copyright Office. And I must say this is a tremendously exciting project. It will be the first ever IP small claims court in the United States. And it will allow individuals who are involved in copyright disputes of a low monetary value to assert both claims and defenses that they don't have the resources to pursue in federal court. Now, the statute requires the CCB to start operations within a year, which means the end of December, although it does give us a little bit of flexibility if that proves not to be possible. But luckily, we're well underway, and I'm hoping that we won't need to extend. So the main breaking news was now a few weeks ago. On July 20th, we announced the 3 copyright claims officers to start the board off. And that's David Carson, who many of you may know. He spent many years as the general counsel of the Copyright Office, Monica McCabe and Brad Newberg from private practice. And I'm thrilled that we have these 3 experts with substantial expertise in both copyright law and alternative dispute resolution to start off the board. And 2 of them have already begun work. Their combined deep knowledge and skills should help ensure the successful launch and operation of this new tribunal. So we're also starting the preparatory work to hire support staff. We're partnering with the library to put in place the infrastructure, including physical space, audiovisual facilities, and an online case management system. And on the regulatory side, in March, we issued a notice of inquiry to solicit public comment about the features of the new system, and we've received those comments now. We published a rule just yesterday, I believe, establishing the procedures for a new expedited registration option that can be used for filing a claim before the CCB. And we expect that we'll be keeping up a very brisk regulatory pace with several groups of major rulemakings throughout the fall. And of course, it's not enough just to build the system. We have to make sure that it will be used. So we are working hard to reach out and make available information about the CCB and its operation to the public. And we've already launched an educational webpage that has a lot of information, including FAQs. So take a look at our website and we will keep updating that. And we're preparing a communications plan that will involve outreach and webinars and online tutorials. So if we go to the next slide, Music Modernization Act. This shows you the timeline. The MMA was enacted in 2018. It was a very major piece of copyright legislation that involved revamping the system for licensing music involving online streaming in the United States. And it required the Copyright Office to promulgate a lot of regulations, in fact, more than the entire 1976 Act. And we completed 9 rulemakings in record time. So that included rules to establish the framework for the Mechanical Licensing Collective, or MLC, to administer the new blanket license. And the MLC is now up and running as of January 1st, and it is collecting and distributing royalties. The most recent development is on July 8th, we released, in consultation with the US Government Accountability Office, a report with recommendations for the MLC on best practices for reducing the incidence of unclaimed royalties. So if you are interested, if you take a look at the report, it talks about education and outreach activities, usability of the MLC's public-facing systems and services, data quality and matching practices, and how to measure success, transparency in the system, a lot of very important issues. If we can go to the next slide. So for the MMA as well, outreach to individuals is going to be key to success. And the statute actually requires that type of outreach. So we've already engaged in about 50 different programs, including to educate songwriters about how to claim ownership of works in the MLC database and receive royalties for their use. We've updated our website, as you can see, with information about the MMA, sorry. And we've prepared a lot of additional printed materials and a newsletter and video tutorials. So we're really going full speed ahead, and you can find all of those materials on our site. Now, it's taken a lot of work to set this up, but the result is well worth it. We're really gratified that royalties are going to be going to the right creators, and statutory licensing is now more efficient for digital music providers. Okay, so let's go to the next slide. So modernization is the third major initiative I inherited, and our enterprise copyright system, or ECS, we really live in a world of acronyms. The system will include the office's recordation and public record, registration and licensing IT applications. And all of it will be not only digitized, but searchable and interconnected and user-friendly. You're going to see a tremendous improvement from a user perspective. Now, I do have to acknowledge that the events of this week, where we had the ecosystem being down longer than anticipated for a database upgrade, that has demonstrated how important it is to move to this new system from our legacy system. And over the past year, we have made a lot of progress and hit a number of major milestones. So we're working very closely with the library's IT office, the Chief Information Officer's office. Our website gives reports on all of these milestones, and the library has established a new copyright public modernization committee to expand communication with outside stakeholders on our IT work on modernization. And the committee held its first meeting on July 22nd. The members were briefed on what we're doing and able to provide us with input, which we're now following up on. So what I wanted to do is just to show you a few highlights from the past year. So first, recordation. Amazingly, our current recordation system is still paper-based. So as you can see here, it's a bit old-fashioned. When we receive documents, we manually process receipt and the accompanying payment, and then all of the information has to be manually typed. And some documents contain indexing information for thousands or hundreds of thousands of works. So you can imagine the effort and time that's required. It is clunky. So in April of last year, 2020, we launched a public pilot of our new recordation module. And this lets us process submissions online, communicate directly with the remitter, and then post the document to the public record system. And right now, the pilot involves only Section 205 recordations of transfers and other documents pertaining to copyright. But we are working now to expand it to include also notices of termination. And this pilot system has really received enthusiastic feedback from participants. We are now in continuous development based on their feedback. We're developing new functionality. And later this year, we will issue another update with the new functionality. Processing time, here's some more good news. The processing time for documents that are submitted and processed through this electronic pilot has been reduced from months to just a matter of weeks, much faster than paper recordations. So we are currently adding waves of public users. And if you're interested in participating, please email us at recordation-pilot@copyright.gov. And we have an internal goal of processing 20% of all recordations this year on our electronic system and moving in the future to a fully electronic system. Next slide, please. So this shows our work in creating a new and improved copyright public record system. It will provide an easily navigable interface and will sync both the current and legacy systems as well as the new ECS applications under development. The current system, which is known as Voyager, has an antiquated interface and only limited functionality, and it has our online public records from 1978 on. Next slide. The new system, our new copyright public records application pilot, was released in mid-December, and it gives access to the same data, but it has new enhanced search functionality and user interfaces. And we'll be releasing an update to the pilot in the coming weeks with new and improved features, so do stay tuned. And then last, if we go to the next slide, what we're doing on registration. I know this is, last, but certainly not least. I know this is of major interest to many of you. Our next generation system for registration will be a major improvement during both the application and the examination process. And we're drawing on extensive user research that we've collected over years of operations, and also using technical expertise in user experience design. And this will really help make our services much more accessible to more people and take forward our copyright for all goal. And the slide shows you the striking difference between the current interface for the user application and what you will see once the new system is operational. So I'm going to stop there. As you can see, the office has its hands full. Luckily, we have a dedicated staff who are really passionate about copyright and about creativity, and they are making all of this work possible. So thanks for joining this session, and I look forward to your questions.
Thank you, Register Perlmutter. We just sent a reminder to everybody, please submit your questions through the Q&A. In the meantime, Register, if I could just ask you, of all these initiatives that you inherited and all the work that's been going on, what has stood out to you? What has been the most challenging or the most rewarding for you in this beginning of your service?
That's a tough question because they're all so different, but I will say the modernization effort is fascinating. And I think there's so much we can do once we've moved forward with it in terms of public accessibility and data analysis and research. So I think it's really a pivotal moment in moving the copyright system somewhere that makes it easier for people to understand and evaluate and use. And I think that's a very exciting point in time. My background, of course, though, is doing policy and international work. So I'm also absolutely fascinated by what Congress is doing, what stakeholders are doing, and looking at how to improve the online system for the use of copyrighted works.
Thank you. We are starting to see some questions come in. I know Kevin is with us today, and I think was going to help us select which questions to focus on. Kevin, I'll just let you take it from here.
Sure, thanks very much. So just kind of going down the list here, and I see the first question is, as you update Voyager, are you considering entering records from prior to 1970?
Yeah, I mean, I think the short answer is yes. Rob, are you able to give more information?
I can give a little more. Thank you, Shira. That there currently is digitized information available from the card catalogs online. The Historical Records Project is ongoing. So, but the end goal would be to integrate that catalog of older records with the current record system. So that is certainly something that is looking forward, something that we are seeking to do. And if I could just add one thing to the first question, when Register Perlmutter was asked what the most challenging issue is, that have to mention that being the first virtual register has to be one of the aspects that has been a challenge moving forward.
Very good point, Rob. Thank you. I did start remotely, and gradually, as I've gotten to meet in person some of the people I work with, we're all amazed to find out how tall people are and that they have feet. Go ahead, Kevin.
Oh, well, I just saw that the next question is about the ebooks requests regarding the ebooks legislation that we received from the Senate Judiciary Committee. I mean, I can just say generally that I know the committee is interested in issues of copyright preemption. The general rule that the federal copyright law preempts state laws that address the same subject matter as is provided in Title 17. That is really the overarching issue. I don't know if there is a more specific question about that, or Shira or Rob, you have anything to add?
No, that's right. And I think the letter that was sent to us requesting that we do the study is publicly available. I don't have it in front of me right now, but it should be findable. It came to us from, I believe it was certainly Senator Tillis, and I don't remember who else had signed the letter. I don't know if you do, Kevin.
We've had a number of them. We had some of the requests were from both Senator Tillis and Senator Leahy. I can't recall offhand whether that one was just Senator Tillis or both of them, but definitely Senator Tillis was one of the requesters.
So I believe it's publicly available, the letter. I don't think we have it posted on our website at this point, but I think you can find it. Okay.
It looks like we have a question about best edition, and I'm going to avoid saying anything about patent law because that would not be productive. But the question is whether best would be similar.
I would say it's not really similar to the best mode requirement in patent law. It's really best edition from the perspective of the Library of Congress's needs for its collection. Rob, I don't know if you want to add anything on that.
With respect to best edition, I think that the library is reviewing some of its thinking and is moving towards desiring to increase its digital deposits into the library. So that's something that could be helpful for both registration purposes. But right now, during the pandemic, without question, the best edition requirement for physical copies has been one of the largest problems that we've faced because we had very limited staff we currently have very limited staff on site. So to the extent, I hate using the word backlog, but to the extent that we have a backup of certain types of works, that certainly is in the category of best edition physical deposits that have been sent to the Copyright Office. And we have rooms filled with with those physical deposits in registration, and there's from 2020, and there are still deposits for awaiting arrival into registration from 2021.
But I would only say if the questioner is interested in finding out more about how best edition is defined, we have a number of regulations on the subject. I don't know if Kevin or Rob, you might put something into the chat directing them where to look. And I think the study that we're being asked to do is particularly to look at how the library's needs, especially in a rapidly changing environment where there's more electronic deposits, relate to what we need for the copyright system in terms of deposits for examination purposes. Maybe, Kevin, I'm going to jump in with one of these questions without waiting for you to ask it because I like it so much. So there's a question: should those of us in higher education and their music departments promote the benefits that the MMA and MLC make to its students? What would be the key information to make them aware of? And so my answer is yes, please, that would be fantastic. I think the key information you can find on our website. So I would direct them there. And also, explain to them once it's up and running, what the Copyright Claims Board will be, because people will want to know about that too, whether to assert a claim or whether in case a claim, or whether to assert a claim or a defense, or to know how to opt out if someone asserts a claim against them. Let's see. Kevin, do you want to take the one about the small claims court interacting with the court system?
Sure. Let me just find it here. Yeah, it's a good question. I mean, I think the short answer is no. So the statute provides that the determinations of the CCB, the Small Claims Tribunal, will not be precedential. And in terms of, so they will be bound by applicable precedent, but the reverse is not true. Their decisions will not be precedential going forward. And then in terms of further interaction with the courts, once the CCB issues a determination, that can then be confirmed as a judgment in federal district court, similar to an arbitration ruling. And there are limited bases upon which the determination can be challenged in federal court.
And now, Kevin, we're reversing roles, because I'll let you answer the next question about the CCB. The question is, the CCB will capped at 30,000 in damages. Nevertheless, would statutory damages still be prosecutable? And I know the answer is yes, but what is it, up to only 15,000 per claim or something?
I believe that's right. Yes, there is a cap on statutory damages. So yeah, the short answer is yes. Statutory damages can be available,
but with limits, which I guess is one of the reasons why someone might choose to not opt out from the CCB if they thought they might be subject to greater statutory damages in court. And another CCB question, I'm just grouping them for us. Will a mutual settlement still be an option? Yes, and in fact, one of the goals of this process is to facilitate dispute resolution, and that's why one of the three officers is required by statute to have a substantial background in dispute resolution.
Looks like we have a question on, I don't know if there are any more CB questions, but I do see a question on more detail on what the alleged state abuses of copyright includes. That seems to be referring to our state sovereign immunity study. I can start off on that. So it's interesting, as the Register noted, there was a Supreme Court case last year called Allen versus Cooper, which struck down a provision of the copyright law that attempted to abrogate state sovereign immunity. The statute said basically that states can be subject to suits to the same extent as private parties. And the decision said that basically the evidence before Congress at the time that statute was enacted was insufficient to abrogate state sovereign immunity. And under the court's precedents, what's required is really a showing that states have engaged in a pattern of, in this case, deprivation of property without due process. So after the decision was issued, Senator Tillis and Senator Leahy sent a request to the office for us to essentially see what evidence is out there now as to whether states are infringing copyright. So we've engaged in really a year-long process where we, had public roundtables and have received public comments both from copyright owners and from state entities, about trying to figure out the extent to which this is a problem, and to what extent it may be sufficient to create a record that is greater than was the case with respect to the last abrogation legislation.
Yeah, and the report that we'll be issuing at the end of the month will summarize all the evidence that we received as to what is happening and what people are experiencing on both sides of the issue. I do see a very specific question about, for modernizing the recordation system, when can someone sending a request today expect to be added to the pilot? And I know we're, putting together a new wave of participants, but I don't know the exact date. Rob, do you know?
I don't, and I just sent a message to try and inquire about that, but I think that you did post the link or the URL to people who are interested in being involved in the pilot. And if you send a request and ask that question at the time, I'm very sure that they will provide information about the timing.
Yeah, so just to give you that again, let's see, it is, I have it here, recordation-pilot@copyright.gov. And then I see a question about, there's some more CCB questions, Kevin, that have come in.
I can just add one update. I did get a receipt from the message and they said that they're adding them in waves. So and a new group was just added in August. So it sounds like they're being added pretty much monthly. So do submit interest if you would like to.
And just a quick response to a question, whether the report on state sovereign immunity would post it on our website. The answer is yes. We try to always post everything and be as transparent as possible. And then two other CCB questions, Kevin. So one is the concern about due process and rights to a jury trial and the fear of creating a troll farm. What can we do to allay the concerns? I think the due process and rights to a jury trial, that's why the proceeding is purely voluntary and anyone can opt out. And that was precisely to preserve the right to trial by jury. So I think that's probably a simple answer to the first part of that question. The issue about trolls, there's a number of safeguards built into the system to avoid that. And I'll let Kevin talk about what those safeguards are. And also, Kevin, maybe the next question, which was, what's the incentive for defendants to stay in since injunctive relief can't be imposed without their consent?
Right. So a few points. Just as a general point, I'll post we did a policy study on copyright, which preceded the legislation, but analyzed a lot of these constitutional issues more generally in 2013. So I think that's a useful starting point for some of these issues. So I'll post a link to that in the chat. In terms of the safeguards, I mean, actually part of the rulemaking process that we're currently engaged in is to establish regulations against abusive practices. So the statute gives the Copyright Office authority to promulgate regulations to, for example, sanction parties or attorneys who are found to be abusing the system. They can be excluded from participating for a period of time. Another safeguard that I just would note is that before a proceeding can be initiated, the claim is sent to the CCB in the Copyright Office, and it's reviewed for compliance with the statute by staff attorneys working for the CCB. So there is sort of a mechanism by which claims are reviewed before they're served on opposing parties for compliance with the statute. In terms of incentives to stay in the system, I mean, I think that one thing we've heard in looking at these issues is that the cost of federal litigation is high for defendants as well. And so one of the real goals I think that Congress had in mind in enacting the Case Act was to provide an alternative for copyright defendants too. There also is specific provision in the legislation to allow DMCA claims, and so that's an opportunity for users to participate in the CCB as well. So I think, the statute was structured with, I think, a real intention to provide appropriate incentives for both users and copyright owners to feel that this was a good alternative.
Thank you. Thank you,
look-
Register Perlmutter. Oh, I'm sorry. If you want to just close.
I was just going to
your
make
closing
one
thought.
other observation about that, which is,
Sure.
it really remains to be seen how much the system is used and how many defendants agree to participate. And I think a lot of it will depend on how risky they think it is that they will get taken to federal court if they don't agree to participate. And then, of course, as Kevin says, there's the ability to get a declaratory judgment of non-infringing use. So it gives you some security going forward that you won't be sued, and the ability to make claims of DMCA misrepresentations and notices. So we'll see. And we have taken into account all of the various comments we got from the public. And so a lot of these issues, for example, how to avoid abuse of the system, will be taken into account in the draft regulations we'll be issuing for comment.
Thank you, Register Perlmutter. Thank you, Kevin and Rob. We're so glad that you could join us today. We really appreciate your time, and we're just delighted to have had you here with us.